He is definition. And so he can use.
Okay. Okay, that's fine.
So, let's see.
We'll now call to order the January 5th meeting of the Ohio Elections Commission. Mr. Executive Director, please call the roll for attendance of commissioners.
Mr. Lyle. Here. Mr. Morris.
Here.
Ms. Hagan.
Present.
Mr. Knight.
Here.
Mr. Kreitz. Present. Vice Chair Kaufman.
Present.
Chair Bay.
Here.
All members are present.
Okay, the first order of business will be the approval of the regular meeting minutes of December 22nd. It's my understanding that there's correction needed today on the records.
That is correct.
Commissioner,
Mr. Kreitz, would you like to?
Yes, sir. Thank you. Mr. Chair, on the last page of the minutes, under other business, first line, the word review should be deleted and the word compensation should be inserted. So to discuss the compensation of the executive director. That way it brings it in line with statute, statutory language. Thank you.
Second. Second. I'll make that change and have it available for everybody to sign.
okay, there's been a motion that's been duly seconded. Any further discussion on the motion or any other questions or clarifications to those minutes? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, the same sign. Motion carried by a vote of 7-0. Okay, next on the agenda be the preliminary reviews. We have case number 2022 G-023, Robley versus Morris et al. Mr. Executive Director.
Mr. Chairman of the Commission, this is a complaint that asserts that a respondent failed to file certain corporate contributor information required by statute. We received a response. The counsel for the respondent submitted an explanation. Both the complaint and the response have been circulated to everybody. Why the information was not initially submitted as part of the report. Counsel for the case effort will be taken by reaching out to contributors from which information was received. That all contributions were submitted, corrections December 6th. And affidavit confirming that was received from the attorney. I know you see what my recommendation is there. I've rethought this a little bit. My recommendation is to find a violation of a good cause, not opposed to fine, or refer the matter for further prosecution. I'm glad to answer any questions that you may have. I don't believe anybody's here for either the complainant or the respondent.
Okay. Any discussion from any of the commissioners? Any questions? Is there a motion on the Executive Director's recommendation?
So moved.
Is there a second?
Second.
Okay, any further discussion on that particular motion? Hearing none, all in favor signify by saying aye. Aye. All opposed, the same sign. Motion carried by a vote of 7-0.
That one, and then we get the hearing.
Okay, great, right. All right, our next section of matter, text matter that we'll be handling is a, you have one case for reconsideration. That's case number 2022 R-346.
Residents for effective
Oh,
government.
Residents for effective green government.
Roberto Ravagnani is the treasurer. I talked with the treasurer. This matter was decided in September And we always reach out to the board, in advance, and ask if there have been any updates. They indicated there was not. So when we decided in September, we found there was a violation. And imposed a per diem fine, $25 per day with a reconsideration option. Subsequently, the board reached back out to us and indicated, it was when we got the email from the board, that the report actually had been filed on August 15th. Even though it was due previous July. The treasurer stated she had filed the report, was surprised about the decision. Obviously, we didn't get the information from the board at the time. So anyway, the committee has filed a report. You see, I've synopsized the statement that she made me. And so, considering the circumstances and the fact that even then, the filing was almost a year late, had this matter been, had we been informed of that at the time when we made our original decision, my recommendation would have been to find a violation and impose a fine of $50. So my recommendation here is to reconsider the matter, vacate the previous imposition of the per diem fine, and instead impose a fine of $50. I'll be glad to answer any questions of the commission.
Mr. Chairman, I just have one question to the executive director. Is the committee terminated?
Yes.
Okay.
At least that's what the board, actually, no, the board did send a copy of the filing with their email, and it reflected termination.
Okay, thank you.
Well, I should have made that clear.
Any other questions or comments from the commission? Seeing none, is there a motion on the recommendation of the executive?
No.
Is there a second? There's been a motion that's been made and duly seconded. Any further discussion on that motion? Seeing none, all in favor of the motion, signify by saying aye.
Aye.
All opposed, same sign. Motion carried by a vote of 7-0. Okay, next section would be we have a hearing. That's going to be handling case number 2021G-022. This Chambers versus Blackstone et al. Case number 2022G-012. Capella versus Blackstone et al. Case number 2022G-013. Capella versus Blackstone et al. And case number 2022 S-002, Ohio Secretary of State versus Blackstone et al. It's a number of people here today. To start things off, would council please make your initial appearance and who you're representing?
Thank you, Mr. Chairman. Scott Pullins, Supreme Court number 76809, appearing on behalf of Sarah Chambers. Thank you.
Chairman Kurt Hartman on behalf of Mary Capella.
Attorney Josh Brown on behalf of Blackstone.
Good morning, Brian Katz and Shanda Behrens from the Secretary of State's office.
Can we clarify, is Sheriff Barron, is she from the Attorney General's office?
Still from the Secretary of State's office.
Okay, I object to any attorneys representing the state of Ohio or not from the Attorney General's office. The Attorney General represents the state of Ohio.
We continue to disagree, as does the Attorney General's office, of the opinion that we are able to appear here today and represent the Secretary of State's
And
office.
I'd like to, Mr. Katz, clarify, are you going to be a witness as well or just an attorney?
I will not be a witness today. Thank you.
Thanks, man. Appreciate it.
Is your objection withdrawn or?
Objection, I just want to note for the record, it's already been addressed by the committee and that's fine. I just want to be on the record.
Just protect the record.
Well, these are 4 separate cases. We absolutely all pertaining. There were certain campaign finance violations committed by the Blackstone campaign relating to expenditures, violations of revised code sections 35.17.10, 13, 13 E, G, and O. And so hearing them all together today. They haven't been officially consolidated, so we're essentially consolidating them for purposes of hearing at this point. And I would certainly recommend that they be consolidated for ease of consideration throughout, but I don't think we need to do that at this point. It's a matter of maybe hearing the evidence that will be considered by both sides as it relates to these finance issues that are presented in the past.
Well, do the four council that are here today representing the parties have any disagreement or objection to us handling the presentation of the evidence in a consolidated manner like this?
No objection.
No objection, Mr. Chairman.
No objection.
No objection.
Okay, thank you.
Well, I think that my understanding, at least the last understanding I had was that Mr. Katz would be moving forward as it relates first to front complainants. If that is different, please let me know. But that's the understanding that I had from conversations with Mr. Katz and Mr. Hartman. And so, if you want to go first.
If I made a few preliminary matters, just to clarify for the record, and to make sure it is part of the record already. Firstly, there was initial testimony already provided in case number 12 and 13, the Capella case. I'm trying to think when, late April, early May. And just want to make sure that that testimony from Jane Blystone, which was continued in progress, is part of the record for this consolidated case, that we don't have to reinvent the wheel with her entire testimony, but just can pick up where we left off.
It would be part of the record of the commission, yes.
And secondly, similarly, there was filed or tendered to the commission a deposition transcript of Mr. Blystone taken in a case in Delaware County. Just want to make sure, pursuant to Civil Rule 32, that also is part of the evidentiary record before the commission already.
That has also been submitted to the commission. It has been provided to all commission members. It is part of the record. And I will go on to add as well that the commission received the deposition of Joanne Swallen in that matter as well. And that has been received as part of the record and has been circulated to all commission members.
So it's part of the evidentiary record already.
It is a part of the evidentiary record.
Thank you. I just thank you for that clarification.
Mr. Chairman, Mr. Director, I intended to make an opening statement if it's wanted by the commission and then defer, as the director stated, to the Secretary of State to present the case.
Okay. Mr. Brown, do you have a opening statement as well?
It's a pleasure to the committee. We have here to give an opening statement.
Yep.
All right. Go ahead and make your opening statement. Pat, are you going to provide an opening statement in the department?
I wasn't planning on it. I think the commission knows the issues already, but
I am, yes.
Okay, so. Start with the Poland, go to Gas, and then we'll come to Brown. And then we'll start with Katz's case. Would that be?
So I believe they've requested to have a witness go today, if they'd like to have their witness go first, or I mean, to that, or however they want.
Well, if we're gonna do open, let's just get those out of the way, but then start, and then we'll have. It's called good.
Mr. Chairman, first as a preliminary matter, this is a legal proceeding. I would ask that you direct the respondent to remove his hat. You know, I know it's his symbol or whatever, but he needs to show respect for this process. I would request that. If it pleases the commission, my name is Scott Polens. I'm an attorney for Sarah Chambers. As I said, I plan to make a very brief opening statement, then defer to the Ohio Secretary of State to present the case. We did subpoena Deborah Abbott to testify here today, and she has a medical issue and will not be available. And we don't think her testimony will be needed. We will supplement and cross-examine witnesses as needed if they are needed. My client filed her complaint over 14 months ago. She received a preliminary hearing and found probable cause over 12 months ago. Then in January 2022, the Blystones filed a lawsuit against this commission of Franklin County and filed a personal lawsuit against Mrs. Chambers in Delaware County. My client has been repeatedly threatened, both publicly and privately. She has incurred tens of thousands of dollars in legal fees defending herself against this Blystone litigation. Meanwhile, Mr. Blystone, who's an attorney, have used campaign funds alone to pursue this litigation against her personally. Mr. Blystone did not run for township trustee or school board. He ran for governor, the chief executive officer of the 7th largest state in this nation. Nonetheless, he still to this day has not hired an accountant. His accountant, so-called, doing an audit is actually the mother, one of his supporters, that is a volunteer. She's a federal government employee that resides in the state of Pennsylvania, and as far as we know, has zero campaign finance experience. Her involvement in this may very well violate the Hatch Act. Additionally, Mr. Blystone did not retain counsel for his campaign till around the time this complaint was filed in October 2021. Whether you call it an admission or a stipulation, Mr. and Mrs. Blystone have both stated under oath and publicly they took in hundreds of thousands of dollars in prohibited cash and corporate donations. They did not exhibit any good faith or best efforts whatsoever in their violations. They purposely did so. If they were ignorant, they were willfully ignorant. Mr. Blystone has repeatedly and publicly stated he does not agree with Ohio's campaign finance laws. He has stated, and you've seen the videos, you should be able to file your reports on a postcard. He doesn't like Ohio's campaign finance laws and made a calculated and deliberate decision not to follow them. They were told multiple times how to follow the law by the Secretary of State. The Secretary of State's campaign finance handbook, which they both admit to never reading, clearly explains that their actions are prohibited by Ohio law. Ohio Revised Code Section 3517.10(4)(e) is not confusing. It's not vague. It's not subject to some other reasonable interpretation. There is simply no good faith defense for not understanding it. Let me read the pertinent part to you. A campaign committee shall keep records of contributions from each person in the amount of $25 or less. Crystal clear. The Blystones did not keep these records. Instead, they personally set up a system that was designed to violate Ohio's campaign finance laws by deliberately failing to collect this information. There is already more than enough evidence before you. From Mrs. Blystone's testimony to Mr. Blystone's deposition to Mrs. Joanne Swallen's deposition, along with Blystone stipulations, there is substantial evidence of multiple violation before you for which they do not dispute and simply cannot dispute. Today, you'll be shown that there is absolutely no good faith, reasonable basis for respondents' deliberate violation of statute. There's no administrative code section. There's no advisory opinion. There's no court case. There's no formal nor informal legal opinion that provides any basis for this after the fact defense. They got caught. I was admitted to the bar of the state since 2003. I've appeared many times before this commission on different matters. I've never seen such a serious and substantial violation of campaign finance laws as this. Mr. Blystone has treated these complaints in this commission like a joke. This is the first time he has ever personally appeared before you. He has repeatedly and publicly attacked me and my client. He has attacked the integrity of this commission. He has accused each and every one of you of corruption, even as recently as yesterday. He has served, attempted to serve, or threatened to serve frivolous subpoenas to a variety of state officials that have zero relevant information to this case. He has attacked the governor, the secretary of state, outgoing chairman of the Ohio Republican Party. He has attacked Mr. Katz, counsel of the secretary of state. He has attempted to disrupt this hearing. He has blamed everyone and everything but himself. I ask you not to reward this egregious bad behavior. The Secretary of State, attorney for Mrs. Capella, and I are here unanimously asking to refer this matter to the Franklin County prosecutor for further investigation and prosecution. I realize that this commission has rarely referred matters for prosecution. However, if a serious message is not sent, then these types of violations will happen again and again. A finding of a violation is not sufficient. A fine, even a heavy one, is not sufficient. Only a referral prosecution will adequately deter these violations in the future. Thank you.
You're fine.
I don't need to.
All right, so Mr. Katz.
Good morning. Thank you. Again, I am Brian Katz, and along with me is Shanda Behrens from the Secretary of State's office. Two initial matters. First, I recognize I'm having some sinus issues today, so if you can't understand me or can't hear me, please just let me know. And then second, in case this is my last time that I get to go before the outgoing commission members, Chairman Beatty and Commissioner Kreitz, thank you for your service. Our complaint today is a 13-part referral for inexcusable and undisputed repeat campaign finance violations. The first 12 parts are similar in that they stem from 3 repeat violations: the failure to file statements containing all information required, the failure to keep a strict account of all contributions received, and the failure to file a complete and accurate statement. The first 3 violations arise from the committee's intentional misuse of the fundraising exemption by reporting entire events as contributions received $25 or less, instead of actually tracking the underlying contributions and reporting those that are required by law. As part of a routine campaign finance examination by the Secretary of State's office, we sent an examination letter to the committee seeking clarity on 55 reported contributions totaling $82,204. The committee's response to our letter acknowledged each entry represents anonymous contributions the committee received without collecting the required donor information. Violations 4 through 6 arise from 39 additional contributions received without the date of receipt and without documentation of the conditions of the donations. This missing report data was addressed in the examination letter, with the committee again acknowledging a failure to track the date of contributions and thus an inability to report the required information. Violations 7 through 9 arise from 14 occurrences of the committee reporting a contribution as anonymous or not listing a contributor at all. The committee's response indicated that records relating to these contributions could not be found, and thus proper reporting is not possible. Violations 10 through 12 arise from 153 contributions reported in the name of either a business, a location, or a description of an event instead of an individual allowable contributor. Again, the committee's response admitted no records were collected or maintained and thus are not possible to submit. Finally, the 13th violation arises from the committee's reporting of cash contributions received in excess of the $100 cash limitation. The committee reported 141 contributions in excess of $100, totaling $99,051. The committee's April 15th response acknowledged receipt of the cash contributions and a lack of documentation or knowledge as to the actual contributor of the the 141 cash contributions, thus again making the required refund not possible. To date, the committee has provided no justifiable defense for these violations, only instead claiming they didn't know better, couldn't find help, or that they are still working on it and would resolve all issues within an arbitrary deadline that they made up for themselves. When really, it's now been more than a year since the first complaint was filed against them, more than 16 months since their lieutenant governor candidate left the ticket after raising concerns on campaign finance violations, more than a year and a half since volunteers expressed concerns about the lack of proper campaign finance reporting, and almost 2 years since our office provided initial guidance on the basics of campaign finance reporting. Since all of those red flags occurred, the committee continues to make amendments with new issues being found, filing reports with more violations, and persistently transacting in an improper manner. The fine for contribution limit violations is up to 3 times the amount of the violations. So by my math, that would be up to $543,765. I'll say that again, $543,765. The fine for knowingly concealing or misrepresenting contributions is up to $10,000. And the fine for failing to file a complete and accurate statement is not more than $100 per day. With the 2 reports at question, that is now up to $86,300 and counting. $86,300 and counting. In total, these violations show a consistent and intentional disregard for campaign finance transparency. Accordingly, it is the Secretary of State's request this commission find the violations egregious in nature and warranting immediate referral to a county prosecutor for further investigation. Thank you for your time, and I'd be happy to answer any questions.
Yes, Mr. Just so we have ourselves, what would your word allow Mr. Brown to make his opening statement? What is the kind of outline of what your presentation is during this hearing? Are you going to be calling witnesses or just making this presentation? What should we be looking for?
So my intent was to just simply call Jane and Joe Blystone as witnesses today.
Okay.
Thank you.
I'm sorry, any other commissioners?
Good morning, everybody. Despite all the hyperbole and charged statements, I appreciate having worked with Mr. Richter the last year or so on this case. He's done a really good job of separating the hyperbole from what's really happening, what's really going on. So I really appreciate that, and I'm sure the members of the commission are doing the same thing. A lot of amendments have been made to the Secretary of State in the last few months, and so in our part of the testimony today, we'll only be calling one witness. We'll be discussing a lot of the amendments that were made, why they were made, and the efforts that were made to try to get it right. Overall, though, I will say I don't know why we're here. The committee has already got the answer to every imaginable question. Mr. Blystone went through over 4 hours of testimony on these subjects in excruciating detail, and that testimony was provided to this committee. The complainants have had plenty of time for depositions and discovery and all these different things, and that is why we made the deal last month. We were able to narrow the issues, and throughout all the testimony today, the one thing I want you to remember is you're not going to hear anything new. Nothing that Mr. Katz said is new. Nothing that Mr. Poland said is new. This has been on the table for over a year, and that's why it was time to make a deal. And Mr. Blystone feels that there has been some unfair treatment. He did ask for some subpoenas, and those subpoenas were not issued by the committee, and the committee, the executive director explicitly refused to issue those subpoenas, which is his right, but we never stated the basis for our subpoenas. We just said, hey, we would like you to subpoena this person. I drafted the subpoena. I think it's appropriate if you say, well, why do you want to subpoena these people? Then make a decision on why you don't want to issue that subpoena. But he simply denied the subpoenas based solely on the name of the person subpoenaed. We believe that's unfair and not appropriate. So we understand you have the facts before you, and we are concerned that the commission has already made up its mind. Since you had the information before you in great detail, but you decided to have this hearing anyway. Our concern is that the only purpose of this hearing is to cause embarrassment to Mr. Blystone, to rehash and review and to restate things that have already been stated and already been put on the record and already been made known. and to do it on video, live stream to the world. And we're not even, we're not even 100% clear what the subject of the hearing would be, to be honest with you, because we don't have any witness lists, we don't have a trial, anything that would be analogous to a trial statement. So we just come in saying, look, you have all the facts, there's nothing new the complainants can put in front of you. So at this point, we're going to sit back and let them do their job and respect whatever your decision is going to be. Since the facts are out there and we have gone through the depositions and submitted the evidence and done extensive amendments with the Secretary of State's office and their filing system, all we want to know now is what the punishment's going to be. You know what we've stipulated to, you know what the facts are. So our mental state now is just tell us what the penalty is going to be so we can move on with our lives. We do think that the penalty should be consistent with other cases. The Freeman case, you issued a $50,000 fine, and that was for purposeful false reporting. Of all the evidence that you have in front of you, there's plenty of evidence of incompetence, and there's plenty of evidence of not getting it right at the end, but there's also plenty of evidence of trying to do the best they could. I'm sure you all read the deposition. You went into detail about the difficulties in hiring the kind of professional staff you needed, the lack of trust you had in what you would call sort of establishment institutions. You know, people like the ORP chair, for example, was mentioned in the deposition. There was just a lack of trust. And when you're dealing with a lack of trust in a complicated system and you make some mistakes, you got to, you put that before the commission makes a decision what to do, and we'll live with it. So, but one thing you won't find on the record is something like the Freeman case, which was a $50,000 fine. You won't find anything of trying to hide the ball or playing a shell game. You're going to find people that just didn't know what they were doing and they were trying to do the best they could. All right, thank you.
Things, just for the record, the requests for subpoenas that were made by Mr. Brown were for Michael DeWine and Franklin Rose, and pursuant to the authority available to me in the administrative code, I did not issue those subpoenas. I believe they were primarily issued for the reason of delay, and that they wouldn't really bring anything pertinent to the commission in terms of testimony as it relates to the issues pending before the commission. Our issues today are related to campaign finance filing violations, and nothing more than that. It is my belief that those two persons would not add any further information clarifying that. The second thing was,
Before we go on to the second thing, is there a, other than his statement today and conversations that you may have had with Mr. Brown, in his capacity, is there a pending motion on the failure of grant those subpoenas?
No.
Okay, thank you.
No. The other thing was that during his opening statement, Mr. Pullins mentioned Deb Abbott, who indicated that she wouldn't be able to attend today after Mr. Pullins subpoenaed her. I talked to Ms. Abbott on Tuesday, I believe it was. And if we are able, if it becomes necessary to move this matter to tomorrow for further consideration, she indicated she would be available at that point. So I indicated to her that I would let her know whether that was necessary or not. That's all I said.
Mr. Brown, came to my attention there might be an issue with you being able to attend tomorrow if it goes over.
I can't be
That's still
here.
the case, or?
Thank you, sir. I can't be here tomorrow.
Yeah.
I cannot be here tomorrow. Just for your clarity, any day next week. I mean, I've been available for the last 2 weeks, the next 2 weeks, but tomorrow's the one day I can't do. So I'm sorry about that.
Unless my I don't want to call them co-counsel, but unless my colleagues intend to call other witnesses, that shouldn't be an issue, sir. We should be able to finish today easily if they only have one witness.
Okay. Okay, at this time, we're gonna take a 10-minute recess while Mr. Hughes prepares the room for witnesses.
Sorry, before you do, if I may, We might be able to save ourselves a whole lot of time if Mr. Blystone's willing to admit to the violations as alleged by our office. Our entire purpose of being here today is to present evidence to support those allegations of alleged violations. If he is willing to, I believe I just heard his counsel say he's willing to admit to them. If he's willing to admit to the violations, we have no further evidence we need to present regarding his violations.
I say, well, I'll talk about that with Mr. Katz in a 10-minute break, and
Okay.
maybe if we need some more time, I'll come back and let you know. But I'm gonna go through the individual things that he's talking about before I go down that
Mr.
road.
Harper.
And I would also ask, I mean, if he's looking at that admission, is he going to admit to the other complaints, what we can agree in terms of admissions? And so then the issue just becomes what is the appropriate penalty or mitigation thereof. Second thing, in terms of the witness that Mr. Brown did indicate that he went to call out of order, which I think all counsel on this side did not indicate any objection there too. I would note, Mr. Richter did provide me just right before the hearing a copy of a letter/report. I don't believe my fellow counsel have formally received that yet. I did share it with them just at the outset of the hearing. He said during the break, I think it would be good just to make sure they get a copy of whatever Ms. Robinson is also.
Can I just add something?
Go ahead.
Thanks, sorry. I just got it yesterday myself. So it's not my habit to give people commissions, things at the last minute like that. I just received it myself yesterday. And so I know he wasn't criticizing me. I'm just saying, I want you to know I don't do business like that. I have many copies here that I can give anybody who wants them.
Okay, do we need to make this a 20-minute break? Council can confer or?
I think 20 minutes will be sufficient.
15.
Split the baby.
15, I would become 20.
Here at 11 o'clock.
No, when you start on time. No.
Right.
Yeah, and yeah. Yeah.
Chris, where are we gonna go? 23rd, just the 23rd. Yes. You got one more.
Oh, it's 20, January something.
January 27th. So, yeah, technically started. So,
Okay, all right, we'll get to these precise things. Okay, that's fine. Ready? Please turn the microphone back. It is on. Ready, we'll now call back. Session. Mr. Secretary.
Mr. Chair, members of the commission, after diligent work by council, for all parties to this case, they are prepared to submit to the commission a motion to approve the stipulated agreement on the consolidated matters. We will need to hear what we hear from council as it relates to this. Submitted, circulated copies to everyone at this point. I guess I would say, Mr. Katz, if you would please.
I believe Mr. Brown is going to present the motion to you.
Okay, Mr. Brown then.
Thank you, Chair. Thank you, committee. Basically, the agreement that you have in front of you speaks for itself. We've all signed it. It will be one of the biggest fines this commission's ever levied. And and we know what the facts of this case are. You've been given everything that I can possibly imagine that could be a fact that would be in question. And I think that the council's worked in good faith together for the sake of finality and making sure that we can put an end to what's been a very long and difficult case. And so I guess I'll just say that we appreciate the work everybody's put into it to make this agreement today, and we hope that you'll accept it.
Mr. Brown, hold on. Would you also be withdrawing all of the pending motions before this body?
From the very first complaint that was submitted, your response included a variety of motions to dismiss.
Sure. Yes. The answer is yes. And in the interest of finality, which is, the spirit of this agreement. And I would also probably direct you to, there's a clause in there about good faith, which I usually put in all the stipulations I write. So that allows for, if there is something that is done and it shows bad faith, the parties can come back before the commission and then you can litigate, whether somebody was not acting consistent with the spirit of this agreement. I think that's broad enough to put the obligation on us as councils to do our job and make sure that we complete this agreement.
And then, Mr. Brown, there's also it's not really addressed in the motion, the issue of the distribution of said funds, when do you think that would be?
I think I have to issue a report. Mr. Chair, I have to issue a report under the agreement to the committee within 30 days. And if I haven't, if there's some reason that I haven't distributed all the funds by that time, I'll explain that in the certificate that I file with this body. But I might anticipate that we should be able to have them all distributed within the 30 days. We only have one problem, which is there's a pending case, but that's addressed in the stipulation as well.
Okay, so cutting all through all that, your answer is that the funds would, because the way this is within 30 days of the distribution of said funds. So you're
Okay.
cut through that is you're telling me that the distribution will be within 30 days of this stipulation.
For the sake of convenience, I will represent to the committee now that I will file a report within 30 days and either the funds distributed or I'll give you a good reason why they haven't been distributed and what the plan is within 30 days of today.
Other council satisfied with that?
Yeah, I think so. I think it's just inherent in every agreement is a good faith effort. I don't think there's the attitude was that, and the way it was drafted is that within 30 days of the distribution, a full accounting from the day forward would be made, where everybody can see where the funds got distributed sooner rather than later. If there's a delay in terms of distributing them, then we might be back to try to enforce that provision. But 30 days plus or minus that is good faith.
Theoretically, it could be 6 months before the commission sees the funds.
Mr. Lyle, into the commission. As I represent to the committee, in 30 days, I will either have it distributed or I will give you a good reason why it's not. And then I'll make sure that you're apprised as we go along, and I'll do that in good faith. And if I don't, then you can consider that a violation of the agreement.
What do you believe would be a good faith reason not to have it done?
There are expenses. There's some contractors and stuff that the campaign has hired. And so my goal is to have that all taken care of, but sometimes there's things that could delay those payments, but I don't see any reason why now. I think I want to, I can't predict the future. Maybe I end up in the hospital or something. So
if we gave you a little time with a date certain, would that be a problem?
I'm glad to stick with the date certain I gave you.
It's not dates.
30 days from today. 30 days from today.
30 days from today.
Yeah, no, I understand. We don't receive a check unless everything's accounted for. It's like, am I misunderstanding that?
I guess what I'm saying is I'll have the distributions done within 30 days. And if there's some reason why, I'll communicate with the commission and let you know why. And if it's something that you believe is bad faith, then we'll be liable for that under the agreement.
The Secretary's office has no objection to amending the agreement to say that it'll be completed within 3 days.
Agreed.
Agreed.
And you filed that?
I have no objection to that. I mean, I don't think we need to amend the agreement. I can just make the representation to you, or I can file a certificate with the commission.
If it's not done in 30 days, I'll file a motion to enforce it then.
Yeah, something like that.
Something like that. That's not.
Yeah.
Okay, fair.
We just spent an hour drafting this agreement.
Mr. Chair, Mr. Brown, I'm sure you've done this, but I want to make sure we made the record on it. You've had an opportunity to review this agreement or the proposed agreement with your clients, the friends of Joe Blystone, Joseph K. Blystone and Jay Blystone, and they are agreeable to the terms.
Mr. Crichton, to the commission, yes.
Thank you very much, Mr. Brown.
Thank you, sir.
Chair, I have a couple questions.
Go ahead, please.
When is the Delaware County Common Pleas case scheduled?
Mr. Nine, to the commission. That case right now, there are 2 summary judgments on both parts and all the filings are made. And so we anticipate a resolution when the judge in that case decides, and for your knowledge, summary judgment is a request to the judge to conclude the case on paper without a trial.
All facts are not in dispute, right?
Well,
We can do it.
in my opposition to summary judgment, I argue that some were in dispute, but so I anticipate that the judge's decision on summary judgment should be final, but there could be an appeal. There's no telling how long it'll take for that to be resolved, but we have agreed to funds that will be held in escrow, and that money will either go to according to the judge's order, or it'll come back to the Elections Commission.
And then, in regarding number 2, and notwithstanding outstanding obligations and legal fees, and you mentioned the contractors and probably have a sense of legal fees. What do you estimate the net fine will be to the Ohio Elections Commission?
The net fine.
Yeah, the 105,000 minus outstanding obligations, legal fees.
Well, the parties agreed that no matter what, it should be more than $100,000.
Okay.
And that was the number that Mr. Richter put out, and it'll be over $100,000.
Commissioners, any other questions or comments?
If I may for a moment, just I thought he was going to actually.
Complainants, respectful complainants, counsel, opportunities briefly address that.
Thank you. I thought he was going to read through it, just to give you a quick summary in case any listening or wants to hear it. So the parties are agreeing to stipulate to the facts that the Friends of Joe Blystone Committee has violated certain Ohio campaign finance laws as laid out by the Ohio Secretary of State's complaint. Accordingly, the committee is agreeing that the funds that they currently hold, roughly $180,000, will be paid as a fine to the Ohio Elections Commission, minus certain exceptions, money being set aside for another pending matter and legal fees. The commission is being requested to terminate the Friends of Joe Blystone, as well as Joseph K. Blystone is agreeing not to run for political office for at least 5 years from the date of this stipulation. Thank you very much.
Yes.
Mr. Cass?
Oh, please.
Again, I just like to make a record on this. You've had an opportunity to discuss this with the Secretary of State or his representative, and it's acceptable.
I am authorized to make this agreement on behalf of our client. Yes, sir.
Thank you very much.
Thank you.
Thank you.
Thank you, Mr. Chairman, members of the commission. Just briefly, my client and I have reviewed this agreement in depth. She certainly isn't 100% thrilled with that. That is sometimes the results of a imperfect process and the need to settle. We have talked to her thoroughly. She does agree with it, and I believe it's in the best interest of her. Thank you, Commissioners.
And finally, yes, I have also reviewed it with Ms. Capella, who is here today, and she again is in assent to it. Kind of the same feelings that Mr. Pollins indicated, kind of a reluctance. Yes, we do agree to this, recognizing, and I kind of said when we were negotiating this, yes, we agree, but it's a little disappointing, in terms of needing to come here today or these past several months over something like this for campaign finance laws, especially as Mr. Pollins indicated in his opening statement, as somebody running for the chief executive officer in the state of Ohio. It's not a school board member. It's not a trustee, mom and pop type things. It's a serious matter. And we were always concerned and still concerned about the message it does send. I think probably the most disappointing point from our perspective, again, like we said, we're agreeable to this, but really the real disappointment is at the end of the day, if you think about it, not a single dime of this is coming out of Mr. Blystone's pocket. This is money that's going to come out of his campaign fund, which were actually money, a lot of small contributions from individuals, some people first time involvement in campaign. That's who's paying this fine at the end of the day. Good, bad, I think it's bad. I think it's though a limitation we've got in our current system. And so those people in a certain sense, those who contributed, those who gave the $25, $50 paid in cash, be reported. Those are the people actually paying this fine. Again, that's kind of the process and procedure when you do these joint and several liability determinations, and that's where we would be at the end of the day. So I say that maybe it's something to look forward to, maybe talk to the General Assembly in terms of not punishing the people getting involved in campaigns, but actually get really personally hold liable the person or persons who are actually engaged in the wrongful conduct. Maybe some other day, but I thank the commission for its time and its patience.
No, I will assert that there are, appreciate council's statements as it relates to this, but the commission is finding a violation against Joe Blystone individually, Jay Blystone individually, and the campaign committee. And so there is a certain level of responsibility that is being placed on parties to this case. As we go through this, if the commission is going to accept this motion to approve the stipulated agreement, then first we consolidate all the cases so that we've officially consolidated them all. And then as a part of our motion to agree to the terms herein, to authorize the chair to sign the agreement on the commission's behalf.
Do you also think we
Obviously,
should,
answer the question.
do you also think we should include the entire motion into the
I
record?
will gladly read the motion into the record if the commission would like to see that.
Did not, there were certain parts of the council summary that were left out in the motion.
Agreed.
So, well, let's,
Okay.
why don't we first handle the issue of consolidation? Their motion.
I move that we consolidate case number 2021 G-22, 2022 G-02, 2022 G-013, and 2022 S-002.
Second.
Any further discussion on the motion? Any questions? Hearing none, all in favor, please signify by saying aye.
Aye.
All opposed, same sign. Motion carries by a vote of 7-0 that the case is consolidated.
Members of the commission, the motion that's pending before the commission to approve the stipulated agreement is the parties in all caption matter, and those captions are, as just read by Ms. Tavares. Case numbers 2021 G-022, Chambers versus Blystone, 2022 G-012, Capella versus Blystone, et al. 2022 G-013, Capella versus Blystone, et al. And 2022 S-002, the Ohio Secretary of State versus et al. The parties in the above caption matter hereby move the Ohio Elections Commission to approve the stipulated agreement as laid out below, whereas parties to an agreement to bring these matters to a final resolution. Therefore, the parties agree to the following: one, for purposes of this settlement, all of the above caption matters, the complaint filed by the Secretary of State should be considered to be offered to pleading. Two, Joe Blystone, Jay Blystone, and friends of Joe Blystone hereby stipulates the facts as set forth in the complaint filed by the Secretary of State, excuse me, in case number 2022 S-002. And that said facts constitute violations of the various campaign finance laws set forth in the alleged in the complaint. Accordingly, the commission may and should find a violation by Joe Blystone, Jay Blystone, and friends of Blystone of the following campaign finance laws. Revised Code Section 3517.4, 3517.32, 3517.13A1, and 3517.13F. In terms of penalty of the foregoing violations of campaign finance laws, the parties agree to the following and recommend: $75,000 of funds of the campaign committee of Friends of Joseph Blystone shall be placed in escrow in the clerk of the Delaware County Court of Common Pleas in the case styled at Joe Blystone et al. Versus Search et al. Case number 2022-CPH-01, 0012 for distribution on any judgment in favor of defendants therein, or as otherwise ordered by the court, with any fund remaining after said distribution to be paid to the Ohio Elections Commission as an additional fine above and beyond that set forth in paragraph 2 below. All remaining funds, item number 2, all remaining funds currently held by the campaign committee of Friends of Civil Rights, which are in the approximate amount of $35,000, that is less than $75,000. It's reflected above, shall be paid to the Ohio Elections Commission as a fine for the foregoing violation of the Ohio campaign finance laws, notwithstanding any outstanding obligations in this matter. 3, President Joe Blystone shall 30 days of distribution of said funds, provided the county with said funds for the date hereof, which has already been discussed in great detail by council. Number 4, Joseph K. Blystone agrees not to run for any political office for a term of 5 years from the date of the stipulation. Number 5, the parties request that the Ohio Elections Commission terminate Joe Blystone committee. Number 6, the Ohio Elections Commission shall retain jurisdiction over enforcement of this agreement. And 7, parties agree to work in faith to effect the terms of the agreement. They agreed to on January 5th, 2023. The council for all parties has signed this agreement. I would recommend that the commission approve the stipulated agreement.
Move approval of stipulated agreement.
Second.
There's been a motion to schedule this. Any further discussion on the motion?
I have a
Question?
yes, Mr. Chair, a procedural question. And I'm fine with the agreement, but does the agreement need to be executed prior to a vote by the commission?
Oh, I'm sorry.
It is.
I did have-
Oh, I'm sorry, you have it, okay, all right.
And I would ask you to amend the motion to, which, because I forgot to mention it, to approve or allow Mr. Beatty to execute the agreement on behalf of the commission.
So
Second.
Okay, there's been a motion that's been amended and there's been a second to that motion as well. Any further discussion on the motion?
Mr. Chair,
Yes, please.
I have one small nit this. I don't know if you need to address it or not. In one spot, fund should be funds distributed. Any funds remaining, 6 funds.
Paragraph 2.
Paragraph 1.
There are 2 of those.
No.
Paragraph 1.
Oh, my God.
Paragraph 1,
One,
paragraph 1, about 1, 2, 3, 4, 5, 6 lines down.
Yes.
Oh, yeah.
Well, I apologize.
good catch.
There was another one in the first line of the second paragraph. I missed that one as I was doing the final adjustment. Sorry.
Okay, all parties stipulate to that change.
Yes.
Yes. Agreed.
Can we move forward with this motion?
No, I believe we're ready to move forward.
All right, great. Any further discussion or questions or comments? Okay, yes.
I think we'll do a roll call. Mr. Knight,
Yes.
Mr. Lyle,
Approved.
Ms. Hagan,
Yes.
Ms. Kaufman,
Yes.
Ms. Tavares, Mr. Kreitz.
Yes.
Chair Beatty.
Yes.
That motion passes 7-0.
Anything else?
There is no other, aside from me noting that the next meeting of the commission is January 26, 2023. There is no other business to come before the commission today.
Thank you very much to the parties that are participating. Thank you.
It's a 5-year time running for office. Next year.
Before you
Always helpful.
yes. Things that you need to provide all of you. So anyway, we can adjourn the meeting.
Second.
Yeah. Okay, you know.
I'm saying.
Person committee, yeah.
You know, if it's live.
Yeah, it should be like, I have a chance.
Okay,
Sure.
good.
So it's tomorrow at